Most of us grew up in freestanding houses where the homeowner enjoyed the liberty to do as they wished on their premises. But the demands of modern lifestyles has changed that over the years. An ever-growing number of consumers prefer living in sectional title spaces, mostly because of the convenience and the security and the peace of mind they offer. But in the mad rush and excitement to own an apartment, many overlook the hidden realities of living in sectional title schemes, often to their financial detriment. So today we tackle all you need to know when you consider buying a flat, an apartment, or even a house in a privately managed setup. Kuphi na kuphi makhama edolobheni aseComplus lakhona ke leli Yilungelo Lakho mina ke ngiSimphiwe Ngongane sanimukela. Buying property in a complex, be it in a flat or a townhouse, is a priority choice for many people who prefer an easygoing lifestyle. Kepha ngalesinye isikhathi ke imithetho yakuma-complex yenda kuhlala kungabi mnanzi. Kepha ke labanyenti bekunene ke le mithetho lena bayiva emva kwendzaba seyingekho indlela ekubuyela emva. And to share more with us about some of these common mistakes that consumers make, let's welcome property attorney Levy, sinaye na Andrew Sheffer, lobuya ke at Trafalgar Property Management, etindlini tefite kusakata ke ePitoli sinakuni Groenewald, yena ke umele i-National Association of Managing Agents. Gentlemen, a very good afternoon and a warm welcome to the show. Good day. First of all, before we get deeper into the discussion, let's focus on the pros and the cons of buying a freehold property and as well as sectional property. I'm going to start with you.
All right, good afternoon, thank you. Sectional title, as you said, it offers lock-up and go convenience. It also offers cost advantages because the costs of the property are spread across a number of owners contributing to that, for example, security. Also, as many cities are densifying to minimize the sprawl of service delivery in outlying areas, the density does lend itself to sectional title development. So you find more options, more opportunities in terms of sectional title properties in centrally located positions.
Yeah. Ellen, is it a wise move buying a sectional title property?
It is, for all the reasons we just mentioned, the security, the convenience of the maintenance, the community. Especially in South Africa in today's times, I would recommend to any new buyer to seriously consider sectional title property or a property in a community scheme like a homeowners association.
All right. Now, Kuni, let me bring you into this conversation in our studios in Pretoria. I mean, the popular sentiment is that it is the way to go buying a a sectional title property. Are you also of the same view?
I'm of the same view, yes, indeed. The urbanization growth in South Africa in the next couple of years will grow astronomically. And as we saw on TV last night as well, that the property market for individual houses is really declining. And Andrew and these guys may allude us more to prices. But yes, definitely, it's growing.
So what questions should come to mind, Mr. Groenewald, when I weigh the options of intending to buy section title property?
Well, the first thing that a buyer should know is, exactly what are you buying. With a freehold property, you buy the property outright. In community scheme living, you buy a section and a share in the common property. So buyers in sectional title or community schemes must familiarize themselves exactly what they are getting. There's a vast difference in the two pertaining to ownership.
All right. Now, how is a sectional scheme run, just financially?
Typically, it's run by a managing agent who needs to be registered with various statutory bodies. But the managing agent takes care of the financial management, accounting, reporting, assists with the audit into the tax returns, and so on. So if you need more detail, the levies need to be billed, collected, debt collection applies, creditors need to be paid and accounted for. And typically the trustees are given detailed management reports monthly, and that leads up to an annual general meeting where the owners are reported a signed financial audit.
So in that case then, what's the role of a managing agent and under what circumstances should they be appointed?
Typically, financial management is a significant portion of the role. Buildings with positive cash flow that have money to maintain, to pay their creditors, to make sure service delivery is continuous, run well, happily, and owners are typically comfortable in that property. So the managing agent plays a significant role in facilitating that, all of which starts with a budget, which quantifies the levies that need to be paid and collected to make sure all of those creditors can be paid seamlessly.
Now, Ellen, when applying for a bond on a sectional title property, I do understand that the bank checks what is owed by the scheme, whether the loans have been taken to cover the accounts, where there have been shortfalls in levies, and if there are any outstanding issues, who foots the bill?
When an owner or a buyer wants to buy a section in a sectional title scheme, normally the bank would only look at that particular buyer's situation. But the banks are starting to become more astute, and they are starting to have a much closer look at the actual financial affairs and maintenance situation of the building. So you may find a bank asking for the financial statements, the audited ones of the complex, and other reports before a bond is granted to the buyer.
So if then there are any outstanding issues, does the buyer foot the bill then?
It would depend on the issue, but if, for example, a buyer wishes to buy a unit in a complex, and let's say that complex hasn't got audited financials for the last 2 or 3 years, and because of that, the buyer can't make the purchase, that could be a scenario where the buyer may be willing to pay the complex to audit their financials, to furnish them to the bank, to get the bond, and then the buyer would be able to recover that after he takes transfer of the property.
Is it fair, though, for the buyer? Is that a legal loophole, in your view?
No, it's not really fair. Typically, if a buyer is looking at a complex that is in arrears or that hasn't timeously furnished their financial statements, that would potentially be a warning sign to a buyer, because the buyer would want to buy into a complex where all the affairs are in order. So that might be something that already turns the buyer off from making a purchase in that complex.
All right. Now, Kuni, in Pretoria, say I see a property and I love it, and I'm in conversation with the owner and the estate agent. Is it necessary to inquire beyond what the estate agent is telling me?
Most definitely. Like Alan has alluded us to, the property management company or the managing agent who deals with the financial management in assistance with the Board of Trustees, they will have the financial records, and one will always advise that irrespective of your estate agent who will give you good advice on the selling points of the property, find out from the managing agent or find out from him who's the managing agent and obtain copies of your financial statements of that scheme. It will give you a good indication what are you buying into. As Alan also said, special levies and financial constraints within a scheme is clearly defined in the audited statements of that scheme. And it's become more and more pertinent that the financial institutions will look even so far as to say whether the managing agent is properly accredited with all regulatory bodies, as well with our organization, to ensure that there's proper financial management. So ask for that statement. It's very important. The levy roll. You can even ask, from them to produce a copy of city council bills where council needs to be paid from the funds of that community scheme. Look at their reserve funds. So financially, yes, ask those questions.
Indeed, and the prospect of owning property is enough to make me so excited to a point where that excitement clouds my judgment, that I can't even ask the most pertinent questions. So what are some of the problems that I should look out for in a sectional title complex before I buy that complex?
I think I've emphasized the financial position of that scheme, but as I said right in the beginning, community schemes are governed by specific rules and regulations, which is also important. When you buy into that scheme, you're excited. And to give you an example, and we all talk about pets, you want to move in there with your 4 dogs. The time you sign that document and you try to move in, there's a rule prohibiting that. So although you're excited, yes, the rule's very important. Don't just sign a document without making sure where the scheme is going financially, where the scheme is going pertaining to the rules that will be applied. Community scheme living, your next door neighbor is only as next to you as thick as the wall is. So you're living in close proximity to one another. And I think, visiting the site properly when you buy the property or intend buying the property, try and see what your neighbors are or who your neighbors are. Because when you've invested in that scheme, you will be bound to all of these rules and regulations and financial constraints. So make sure what you buy, although you're excited, it might not be the right one for you.
All right, Kuni, we'll leave you there for now. Make sure that you read all the rules before you sign on the dotted line. Please join us after this break. Asikwamukele futhi mbukele tincingo tefe setivuliwe nawe ke ungabeka umbono wakho noma ke umbuto ngendzaba yethu namhlanje kusishaya icingo ku 011 714 6918 noma 011 714 6919. You can also email us your views to consumer@sabc.co.za noma ke usibhalele ku Facebook na ku Twitter. Now we continue with this conversation. Now it seems that there's a whole lot of amount of admin that goes into living in a scheme. The rules, the body corporate rules and the correspondence. Ukuni just mentioned some of the rules and the meetings and the dispute resolutions. Well, when all I have to do is simply to look up and go.
Yes, in a complex, in a sectional title complex, there's two types of meetings. There's meetings where the owners meet together. Those are called general meetings. And typically once a year, there's an annual general meeting where all the owners come and they decide the big decisions for the complex. So any buyer buying into a sectional title complex can request the minutes of those annual general meetings. And he can see what was discussed if he wants for the last 3 years, the last 5 years, or the last 6 or 7 years. Those are called the owners' meetings. Then every complex has a board of trustees that they elect to run the complex. Those trustees also meet periodically and they minute their meetings. So a buyer buying into a complex can also request the minutes of all the trustees' meetings, and he can see what the trustees have discussed over all their meetings if he wants to decide whether to buy or not.
Right. Now, Andrew, you agree? Your thoughts on this?
Yeah, I mean, that's correct technically. I think, the role of the trustees in a sectional title scheme is to make sure it runs smoothly and with sustainability in mind. So typical issues that arise are financial, where the body corporate does rely on people paying their levies promptly to service their creditors. Yeah. If people don't pay their levies, it puts pressure on the remainder of the owners to pay theirs on time so that the body corporate cash flow does work out. Other issues are maintenance, where owners may or may not agree that maintenance is their responsibility, yes, or that of the body corporate, and that responsibility line is quite important to draw, and disputes arise around that, which can either be resolved by the trustees or it may need to be escalated to the community scheme ombud service. Also the rules. An important role of the trustee, supported by the managing agent, is to enforce the conduct rules, which are really there to make sure that everyone living in close proximity can live harmoniously and comfortably, and that expectations are managed around those rules.
Okay. And I suppose it's very important to ensure that the complex is very well managed, as you just mentioned, ensuring that everybody pays their levies on time. Because if they don't, then it presents a huge strain on the body corporate, because some of the complexes, they become in a terrible state of repair.
No, exactly. I mean, the two things that happen first when levy payments aren't made is, one, maintenance falls behind because the building can't keep up with it. And quite quickly, you'll see that in terms of faded and cracked paintwork and the like. Secondly, municipal accounts can fall into arrears, which puts the complex at risk of being disconnected from their municipal services.
Okay. Now, Kuni, what are some of the common disputes at complexes, and how have they been resolved?
Well, firstly, one could commend the community scheme ombud service, which is now functioning. It's a platform for dispute management. As I said in a previous interview, the managing agent is there in a supportive role, but sometimes needs to step away based on his agreement that he has with that community scheme. And also, as I said, staying in so close proximity to each other, I think massive disputes, and Alan and Andrew has alluded to this, financial issues, and then disputes on the rules. We call it parking peds and noise. Staying next to your neighbor in terms of the rules, you cannot, have a function and continue until 3 o'clock in the morning. Yeah. Parking is always an issue. Again, what do you buy? If you buy into a community scheme, you will have a 2-bedroom unit as an example, but only one parking space. Being a preferred method or a manner of occupancy nowadays and property ownership, that unit may be occupied by more than one person and find that a family has 3 vehicles. What now? Also, the other thing is occupancy. You know, a 2-bedroom unit cannot be occupied by 50 people, and that puts strain financially on this community scheme. It creates an issue between the trustees who need to enforce these rules, and eventually a matter like that will end up with the community scheme ombud. And maybe also, if I may, you know, maintenance as well. A lot of community schemes in the past lacked maintenance. Nowadays, with the community scheme and the change in the financial systems and reporting with the administrative fund as well as a maintenance fund, this is slowly being resolved, but still remains a dispute in schemes.
And one particular dispute that I know of, you know, in some cultures, you know, families are allowed to live in, like 3 or more families are allowed to live in one household. And, you know, this is against the rules of some of these complexes. And it's safe to say that it stands in the way of cultural practices of some, you know, of some cultures. How do we navigate around this particular issue?
It is clearly, as you said, a cultural issue which one needs to take into account, and can make life difficult for the property management company and the managing agent and the trustees. But awareness is very important, and I think there's a massive drive in South Africa now in the property industry where education to the prospective buyer in a community scheme is underway. I mean, we and Alan and everybody else offers these training seminars. And I think one must not forget that an owner, when you buy, make sure what you buy, the fact that you have not done your homework in pertaining to occupancy, for instance, doesn't, you know, indemnify you against the infringement of the rules. Different municipalities or local authorities might have different rules regarding this. But I think, you know, occupancy and the financial strain on this is massive.
Yeah.
So you need to find it as an owner, and they can act against you and take you to the community scheme ombud to try and resolve the issue. But they need to uphold certain rules as well.
Okay. Now, Andrew, let's talk in detail about the issue of levies. What's the implications of not paying your levies?
Well, firstly to say we come across many owners who aren't aware of levies in the first place. So they seem to know about their bond payments and expectations from speaking to the bank. Yeah. But then levies become a surprise and they haven't planned to pay their levies, which becomes a serious issue. So they often ask us, what do levies cover and what are they for? And the answer to that is that it's broken down in the budget, which is presented at the AGM. And part of the due diligence of deciding to buy in a sectional scheme should be to look at the budget approved at an annual general meeting, which will be reported in the minutes, and to understand what the levy is, what it pays for, and to make sure that that is affordable and part of your monthly budget as a house owner. But the real problem is the body corporate relies on that money, the levy payments and the cash flow, to pay their municipal services, their security, their maintenance, insurance, managing agent fees, etc., and that keeps the body corporate functioning. As I said earlier, if those payments aren't made on time, very quickly maintenance can't be done because there's no money to pay it. Municipal accounts fall into arrears. Then interest and penalties starts being raised on those accounts, and as you can see, you can quickly get into a vicious circle with that.
Okay. So what then happens if I can't afford to pay the levies? I mean, I imagine a scenario of losing a 1.5 million rand property just because I wasn't able to pay levies worth maybe 15,000 rand.
Well, the first thing to say is speak to the managing agent quickly and early. You know, much like the bank, speak to them, approach them, arrange an acknowledgement of debt and a settlement plan so that there are no fees and penalties raised on the account and that the repayment of the arrears is organised and clarified. So that's very important. Ultimately, if levies aren't paid, it will proceed through a legal action, ultimately potentially losing the property in a sale and execution process.
All right. Sentivele ke babukele ukuthi nangabe awukhona ukubhadala ke emalevi noma ke imali loyibhadala ke kule body corporate lapho uhlala khona, khuluma nelibhange lakho, khuluma nale body corporate yakho ngoba sibalekela indzaba yokuthi utawuluza indlu ngoba or maybe 5,000 noma 10,000 rand just because you were not able to pay. Bukele asesiphinde sibele ngasetolo. Please don't go away. We'll be right back after this. Welcome back, everybody. Our numbers to dial are 0117146918 or 0117146919. Now, these are participation lines. Shala ucingo noma usibhalele i-email ku-consumer@sabc.co.za. Sikhona futhi nasenkundleni yekuxhumana i-Facebook. Sineke namhla ke bekunene sikhuluma ke ngenzaba yema-complexes noma ke ema-sectional title property. Yini lokumele ukubuke before uthenge leyo unit yakho kuleyo complex yakho and all these other underlying issues. And we are in conversation with property experts in our studio. Now, who is liable, Andrew, I'm going to start with you, for that special levy before registration and after the sale?
So typically it will be the seller up to the date of transfer. And then from the date of transfer, when the new owner is registered at the deeds office, they would become responsible for costs against that property.
Okay. Now, Ellen, let's talk about the issue of insurance then. Who is liable to pay insurance? Do I pay insurance for my own unit, or that's the responsibility of the body corporate?
In a sectional title complex, the complex has one insurance policy. And the main part of the insurance is to cover the actual buildings in the event of damage to the buildings. For example, an aircraft flies into the building or there's an earthquake, and to rebuild the buildings. So you might have a situation where there's 20 flats and there's some land subsidence, and the land shifts and some of the flats cave in. That's where the insurance policy would kick in, and the insurance company would pay to repair or rebuild the flats. So in a complex, what happens is the body corporate makes payment of the insurance policy, and they recover the part of the premium from each owner, depending on the size of their flat. So if my flat is half the size of yours, I'm going to pay half of what you pay every month in my levy for the insurance policy.
Okay. Okay. So can I or should I demand statements from the body corporate to see whether they've been complying with premiums?
Well, as a new buyer in a complex, there's a lovely management rule 27, and that gives you access to a whole list of documentation. So if you're about to buy a sectional title unit, I would recommend to all the consumers out there, the moment you see the flat and you like it, have a look at Rule 27, request all the documentation. So when you're ready to put in your offer to purchase, you've already had a look at the insurance policy, at the AGM minutes, at the rules of the complex, at the maintenance plan for the complex. And then you can decide, is this really a flat that you want to buy? Or is this rather a flat you should stay away from? Because there's very serious negative issues around this complex. Just one point is, as the buyer, you're not entitled to the documents of the complex because you're a nobody. But the seller is the owner, and they're entitled to everything. So the seller would need to request everything for you as the new buyer.
What do you mean the buyer is not entitled to these documents? Because once I pay and I do everything, all the documentation, then that automatically entitles me.
Yes, so as soon as you're a registered owner, you have the entitlement. But
after registration, that is?
Yes, but at the time of viewing and before registration, only the seller, who's then an owner, can request those documents and furnish them to you.
All right. Andrew, do you want to weigh in on that?
Yeah, I think it just goes to due diligence. So when you're about to buy a property, it's a very significant financial commitment. In most cases, it's the biggest commitment a person will make. But due diligence is critical, and as Alan was saying, those are the documents one needs to read through to make sure everything is in order and meeting expectations. And there's certain red flags one should look for, which we've spoken about today: levy arrears, maintenance plans not being available, the condition of the property not up to scratch, high levy arrears, municipal arrears, etc. So do the due diligence, read through those documents, make sure you're fully aware, and be informed before making an offer to purchase.
All right. Now, Kune, if I see the need of maybe doing alterations on my property, maybe in a freestanding house within a complex as a result of an expansion of the family, I have a much bigger family, does that constitute as a breach of the rules? Because it is within my yard, it is within my, my unit, and I'm paying my own money towards those renovations or alterations.
Yes, indeed. One will have to get approval for that. It's not just adding on. That's exactly, as I said in the beginning, community scheme living. And what do you get? You get a unit, and then you get an undivided share of the common property, where certain exclusive use rights may be deferred upon you, but it remains common property. if you want to extend a unit, it will have a direct impact on the levy calculations, not only of the unit that you have purchased, but also that of the rest of the scheme and all other owners. These units may be bonded. You're looking at changing the diagrams and the sectional title plans for the extensions. So there's a whole lot of things that you need to consider. Also, you know, why are you extending it? Like you said, is it an additional room? Is it an open patio? Has changes been made, or is it necessary on the initial site plan? So there's a process. One cannot assume that when you do buy into that scheme with your extended family, tomorrow morning you will add on an additional room. That will be deemed illegal, and the body corporate can accordingly act against you. Resolutions need to be taken, plans need to be submitted. So the process is quite lengthy, and I think it can be quite costly as well before you even get to the point where you've been allowed to extend that unit or add an additional room.
I'm quite curious to know, though, how is that affecting the other owners of the property within the complex if I make alterations to my unit?
Well, first, you need to know what the owner intends to use that unit for, or that alteration for. We were talking about the number of occupants in a unit. You've got a unit where the parking is an issue when too many people are going to occupy that premises. The financial constraints and liabilities, if you make that alteration, who is eventually going to pay for the maintenance and the upkeep of that alteration? I'll use the example of a person who wished to build an undercover braai area. Your next door neighbor is at a very close proximity to you. Will that create a disturbance? Because in community scheme living, you may not use any part of the section, common property or exclusive use area, where it infringes on the rights and the use and enjoyment of other sections as well. So it's very important that you do your planning properly. And when the Board of Trustees receives the application for that change or amendment, they need to make sure that due diligence is given to exactly what are they going to approve in the long run. The municipal or bylaws may also restrict an extension. In any community scheme on the common property is only allowed a certain percentage of undercoverage by roofs, for instance. And if you exceed that, they will also not approve the plans, which will make it impossible for you to extend that unit.
Okay. Now, Ellen, have you come across such issues, such disputes wherein the body corporate sues the property owner or charges the property owner?
Every day in my law practice, we come across disputes between body corporates and owners. Sometimes the body corporate has the claim, sometimes the owner has the claim. And it can be related to, like we've touched on, parking, pets, noise, parties, businesses on the premises. Airbnb is a hot topic at the moment.
Yes.
Ritual slaughter of animals is also a hot topic at the moment. So if you're a prospective buyer of a sectional title unit, or a homeowners association, like we've said, have a very close look at the conduct rules. Make sure that they allow what you want to do. So if you want to have ritual slaughtering of animals, or you want to run an Airbnb or other short-term leasing, you've got to, when you see the property, request the conduct rules and see that this flat is suited for its intended purpose.
Yeah, speaking of Airbnb, how is that a problem? How is that problematic?
We're seeing a massive shift in South Africa at the moment with Airbnb, and there are some movements at the moment. There's an amendment to the Tourism Act that's open for public comment, and potentially what the minister is seeking to do is to regulate Airbnb, because Airbnb is taking away a lot of business from the hotel industry. Already you find a lot of sectional title complexes are having issues with Airbnb, because what happens is you have guests arriving for one night or 1 week. They don't know the rules of the complex. They throw late night parties. They park incorrectly. The normal occupiers who live their peaceful lives there don't want those types of interruptions. So you do find many complexes already amending their rules and saying no Airbnb, no short-term leasing. On the other hand, some complexes, for example, in Sandton City, they encourage Airbnbs because it leads to investment in their complexes as investors buy the units so they can be rented out.
Right.
So it all depends where the complex is and what the owners want their complex to be like.
So can the owners then amend the rules of the Body Corporate?
They can. They're called the conduct rules, and you need what's called a special resolution to amend the conduct rules.
Okay.
In general terms, it means 75% of the owners. So if there's 100 owners, 75% can say, let's amend the rules, and they can outlaw Airbnb or they can allow Airbnb.
I see. Ake bekunene asasiphinze sibuyele ngasetolo ningasanyakade siyabuya khona nyalo. Asiphinze sikwamukele futhi mbukeli leli ke Yilungelo Lakho, it's your right. Ungavakalisa umbono wakho ke ukushayela licingo lapha e-studio. Our participation lines are still open. The numbers are 0117146918 noma ke 0117146919. Email yethu ke consumer@sabc.co.za. You can also visit our Facebook page and leave a comment there. Now, gentlemen, the scheme that is heavily reliant on such mechanisms as escalators or swimming pool or motorized gates, I understand that it also affects the amount of levy or the rates that an owner needs to pay, doesn't it?
Well, certainly they need to be serviced on a monthly basis.
Because of the maintenance issue, yeah.
Yes, so in fact there are regulations which require lifts to have a service provider in place. They need to be serviced every single month, so there's a cost to that which will be covered by the monthly levies, and they also need health and safety inspections every 2 years to make sure they are legally compliant and safe to use.
Okay.
And that has a cost as well.
All right. And then the financial health of the scheme, can I request a copy to see whether everything is still in order?
Definitely. As we said before, the Management Rule 27 gives an owner access to a whole lot of documentation of the body corporate. So if you're a buyer, then by all means request the seller to request all the financial documentation from the body corporate, and then have a very good look at the audited financials. See what situation the creditors are in. Does the complex owe 10 million rand, or does the complex owe 1 rand? If they owe 10 million rand, that's probably not a complex you want to buy into, because as soon as you buy into that complex, you and the other 10 owners become responsible for their 10 million rand.
Yeah.
So have a very good look at the audited financials, for example.
All right. Mr. Kuni, Groeneveld, do you also agree, or also of the same view?
No, for sure, definitely. And as Alan has just mentioned, estate agents and now the financial institutions also on a constant basis ask the financial statements. Being the bondholder of that property for quite a considerable time, they also invest their capital into it and want to make sure that the finances of that scheme is sound. From a legal perspective, one does not want to sit with a financial institution being the owner of a property in a community scheme because of repossessing such a unit in the long term if levies is not paid. So they want to make sure that they protect their interests as well.
Okay. And what are some of the common mistakes that potential buyers and buyers do?
In terms of the financials, as we've discussed, and not looking at due diligence, but you know, it's a personal matter as well. When you buy a property and you have secured and have sight on all of these documentations that we've been discussing this afternoon, you also need to, as the buyer, look at your own financial situation. It might seem fair that you buy a property for a good price. At the end of the day, you now become liable for levy payments. If you didn't do the due diligence, you must consider the fact that you might be in for special levies going forward. And as I said, your personal expenses. One's personal income might not grow as extensively as the expenditure of a community scheme, where you might find in the long run that you urgently need financial assistance by means of special levies. Are you going to be able to sustain that additional expense on your personal budget? So you need to sit to make sure that your finance can balance at the end of the day to what you are prepared to, pay and invest in.
All right, let's take our first callers. Sina Miss Lee, lapha Kilane. We're very good afternoon and a warm welcome to the show.
Good afternoon. Thank you for taking my call. I live in a body corporate in Johannesburg, and the question is that once you've bought a unit and you wish to effect some alterations, you submit your request and your plan to the body corporate.
Yeah.
Once the trustees have issued you the approval, they also issue you a time limit. In other words, they ask you, when will you commence and when will you complete your alterations? In the event that they do not complete their alterations timelessly according to the date they've given, is the body corporate entitled to levy a fee for every day or week that goes beyond that period?
All right, Ms. Lee, thank you so much for your call. Our guest will certainly answer that question. Andrew, do you want to answer that?
Yeah, certainly. I think the main concerns for the body corporate are, number one, is it compliant with the rules in terms of the aesthetics and not changing the floor area? Secondly, noise and disruptions to the other owners, certainly the ones immediately adjacent to the alterations. Okay. And thirdly is damages to the body corporate equipment, such as the lifts, taking building materials up and down. Yep. And typically that's why they try and compress the time as much as possible. Some body corporates will require a deposit to be lodged with the body corporate to safeguard damages and to make sure that's available for repairs, and just to be able to be aware of how this program unfolds. I would just say it's important to notify the trustees of any unexpected delays. Typically they're not unreasonable if they're consulted and advised. Building projects do often overrun, but certainly any penalties would need to be provided for in the rules to be enforceable.
All right, Ellen, your response?
So like Andrew's saying, what we're saying is if you're an owner and you're in the process of extending and you being penalized and on your levy statement appears a penalty fee, you must request a copy of the rules in substantiation of that fee. If they're in the rules and they're reasonable, then they can be debited. If they're not in the rules or they're unreasonable, then they can't be debited. Okay. Also to bear in mind that you're as an owner who's extending, you're only liable for your additional levy, because as we touched on before, if you extend, your flat becomes bigger, and then you're liable for a bigger piece of the levy in the whole complex because your flat's now bigger. Yes. You would only be liable on registration of that extension by the Register of Deeds. So be sure that you're not debited and your levy doesn't go up before it's supposed to.
Okay. Mr. Khuni, your response to Ms. Lee's concern?
Yeah, I agree with what the guys are saying, and if you apply for the changes or alterations purely for the fact of delaying it, eventually, because you're selling your unit and hopefully your application will pass on to the person who's going to buy your property because it's a condition of sale, or maybe have your property sold much quicker. You need to take all of that into consideration, as the guys have said.
Okay. Then another big mistake is failing to investigate the exclusive use rules of the scheme. For instance, you've just mentioned the parking bays and the garages. So if it's not included in the deed of sale, can I do as they please then?
No, you cannot. The exclusive use right, when you sell a property, automatically ends, or it can be revested within the body corporate. You can buy your contract of sale, have it then re-registered, but that must be a clear condition of when the property is being sold. It's not automatic.
All right, let's leave it there for now. Let's take our final ad break. Sihlangane futhi nasibuya etitolo. A warm welcome back to our very last segment on the show. Gentlemen, we cannot overemphasize the importance of letting people know, or potential buyers, of using registered estate agents. Just what's the importance of using them who are registered?
I would suggest to any buyer out there in South Africa to always request from your estate agent selling you the property or representing the seller that estate agent's fidelity fund certificate. What that means is a person is not allowed to act as an estate agent unless they have a current certificate, which means they're registered with the Estate Agency Affairs Board. If they're registered, it means they've got to undergo mandatory regular training, which means they are then equipped with the skills and the expertise to advise you as a buyer on what you need to look out for when buying this property. So always make sure that the estate agent is registered, has a Fidelity Fund certificate which is current, because then you are better protected in terms of having this person answer your queries and ensure that you make a good purchase.
Any legal implications of using one that is not registered?
It is against the law for a person to act as an estate agent if they don't have a Fidelity Fund certificate. So for that person, there are legal ramifications. But for the buyer or seller to use that person, there potentially wouldn't be any legal ramifications.
Okay. And I guess, Andrew, the problem is some of these estate agents, they don't explain some of the issues we've been discussing throughout the show to the potential buyers.
That's correct. And like you say, you don't know what you don't know.
Yeah.
So I think it's very important that buyers consult friends, possibly relatives that have bought before, and really do some research on their own of what factors to look for, what due diligence should comprise, and even managing agents are available to answer questions. So I'm frequently approached for advice and input on some of the due diligence elements we've talked about.
Yeah. And, you know, some of the estate agents, Kuni, they don't advise potential buyers of, of some of these issues that may arise.
It is true, but as Alan and Andrew has mentioned, legislation and regulation is becoming much more tighter. We will soon see the new property practitioners bill, which will include any person, involved in property management or sale or rentals, being more tightly bound together by regulations. As Alan and Andrew also mentioned in terms of managing agents, all our managing agents are accredited by means of their Fidelity Fund cover. They undergo training, so they are a professional company who knows the information that they need to provide to the trustees and owners. And if you can find out who the managing agent of that scheme is, make sure that he's also regulated properly. It's not only an estate agent. A managing agent also needs to have a Fidelity Fund cover and be registered with the regulatory bodies.
Can a buyer or a potential buyer use the services of an estate agent? I mean, can they do it on their own without their services? And how difficult a process would that be?
An estate agent can be approached by anybody. Owners amongst themselves also do engage into the sale of properties. I think contracts can be widely obtained all over. But one would always advise that use a professional estate agent. Make sure that the scheme that you intend buying is serviced by a properly registered and accredited managing agent. And those managing agents also have a very good relationship with service providers in the industry to render good advice on items outside the scope of the property management portion of it, maintenance, legal aspects, etc.
All right. Now, Andrew, your final words, maybe words of advice to buyers, potential buyers and owners of properties and sectional title.
Thank you. I think we've emphasized the importance of due diligence when deciding to buy into a sectional scheme. And, that would involve a very careful assessment of the financial status of the body corporate, looking carefully at the reserves. If there are reserves, typically that would give some peace of mind that the building can meet maintenance expectations, creditors, etc. Also understanding the rules and the impact of those rules on your preferences, culture, the way you prefer to live. We've talked about pets, parking, washing, noise, etc. So understand the rules in the context of those common pitfalls. Security is a big ticket item. So, very important to really do a detailed site survey, not only of the unit being sold, but the overall complex, the common property, because every buyer has an undivided share of that common property, the maintenance of that common property, and so on. So it's important to do that site survey with the financial due diligence, understanding the rules before making an informed decision. And if one's not certain about anything in those documents, ask for help. Okay. Ask for help from a registered estate agent, a managing agent, family, friends, an attorney, but ask for advice and make sure that the buying decision is well researched.
Where do I check the register of registered estate agents?
On the Estate Agency Affairs Board website, there is a register of registered agents.
All right. Now, Ellen, your final thoughts, your tips, maybe?
What we're basically putting across to all the viewers out there is that when you buy a flat in a sectional title scheme, it's not only about buying your 2 or 3 bedroom flat. You've got to open your eyes and have a much broader look at everything around you. You've got to look at the whole complex.
Yeah.
Is this whole building in poor condition, which is going to then put a hole in your pocket over the coming years, or is it in very good condition? So have a good look at the maintenance and condition of the building.
Okay. Yeah. Groenewald, your last thoughts?
I think we've discussed it, and as I said, even prior to being or becoming the owner, once you are the proud owner of a community scheme unit, also look at training yourself, get involved in all training sessions and source information on what you need to know going forward.
All right, gentlemen, we can't thank you enough. We appreciate your time. Thank you so much for joining us.
Thank you.
Let me thank my guests for making time to be with us today. Join us again next Monday for yet another Consumer Affairs show. And remember, our programs repeat every Thursday night from 11 p.m. on the same channel, SABC 1. From me, Simpiwe Ngone, and the rest of the team, wishing you a great week. Cheers.